As moderator for this panel, we have Mr. Adrian Winstanley, who's a solicitor and arbitrator in the UK. He has over 17 years of experience at the top of the LCIA as Registrar and Director General, and was also the LCIA's Executive Director. We have as speakers Mr. George Byrne, not the American comedian, but the head of international arbitration at Berwin, Leighton, Paisner. We have Mr. Naresh Thacker, who is the head of litigation and dispute resolution at Economic Laws Practice. We have Mr. Aditya Sondhi, who is the Advocate General of the state of Karnataka. And we have the additional Advocate General of the state of Karnataka. I'm sorry, my mistake. And we have Mr. Charles Beer, Queen's Counsel at Fountain Court Chambers. Thank you.
Well, thank you all very much, and for your continuing patience at this excellent conference as the day wears on. Zia, you may have noticed, is not here. It's not that she is hiding, but she is, I believe, on her way to co-moderate this panel with me. As introductions have already been made to the panelists, we can press on. Everybody has his or her own particular hot topic in arbitration. It's important to stress that some topics remain hot for a number of years, and some are hot as in very recently off the press. We have a mixture of those. We're going to do things a little differently with this panel, if we may, from hitherto, in that we'd like to present each of the topics and then go to discussion among the panel and on the floor, rather than leave everything until the end for Q&A. We'll see how that works, if it's all right by you. Now, Aditya is going to start our session with the broad topic of conflicts of interest and regulating the conduct of counsel, a subject that has been touched upon by the last panel as well. Charles will go next on the subject of third-party funding, then George on summary judgment in arbitration, which is definitely a very recent hot topic, and Naresh will conclude on the subject of expedited procedure and the emergency arbitrator. So given the time constraints here, what I intend to do is to impose a limit of 7 minutes on each of the speakers, after which we will throw the topic out for discussion among the panel and the delegates for another 7 minutes before moving on to the next. So without further ado, Aditya, please start us off. Thank you very much.
Thank you, Adrian. You are a tough taskmaster. The Eddie Jones of international arbitration, if you will. I believe that there's already been some discussion on conflict of interest. And I was interested to see that what was left deliciously vague in the Indian Arbitration Act prior to the amendment, which was a need simply to disclose justifiable circumstances that led to an arbitrator's independence or impartiality being doubted, is now a laundry list borrowed largely from the IBA's red lists, orange lists, and green lists, and codified in the schedule of the Indian Arbitration Act. I think at first blush it's a welcome development because it crystallizes, in a sense, at least the dimensions that arbitrators must think along before making disclosures and reflecting on conflict of interest. But on the flip side, I find that the more you define and the more you sort of list out, the more it takes you into interpretation. And I was amazed to find recently that this question has already reached the Supreme Court. The Indian Supreme Court had to decide on whether Justice Lahoti, the former Chief Justice of India, was disqualified from being an arbitrator on a dispute involving the Gas Authority of India, whom he had given an opinion to some years ago on a completely independent matter. Now, the list or the schedule itself does not deal with that as a disqualification per se, but perhaps for good order's sake, the arbitrator made that disclosure to the parties. And what's amazing is that that was then taken up to the Supreme Court, questioning his impartiality. And on a slightly stretched interpretation, that even though that aspect of him advising a party previously on a separate dispute may not be expressly a disqualification, the existence of a business interest under Schedule 7, which is our red list, would disqualify someone from arbitrating. I think rightly the Supreme Court turned down the challenge, holding that a business interest is a direct pecuniary interest involved in the dispute or the parties, and surely cannot be extended to having professionally advised a party to the dispute on an independent matter. But what I think this suggests to me as an intuition is that if something like this involving an ex-CJI could be dragged all the way to the Supreme Court and it can cause embarrassment to arbitrators, then I think the tendency to litigate now on an interpretation of Schedule 5 and Schedule 7 is going to increase. The aspects that were left vague earlier, in many ways, the councils also ignored. I'm quite sure that prior to the amendment, something of this sort would never have reached the Supreme Court, but now it has. The other aspect for me is, and this is something I personally grapple with as well, is to what extent does this list close the circle? It's only a guide to your impartiality. It's not the last word on it. So what happens in situations where one is approached as a senior counsel to act as an arbitrator by a law firm for whom you have appeared previously in independent disputes? Now, the list by itself does not deal with it. Schedule 7 has a reference, I think in entry 3 or 4, which talks about an arbitrator acting currently for a law firm as an absolute disqualification. But by implication then it suggests that if you have previously acted for a law firm, that by itself would not disqualify you. But then, do you need to make that disclosure? Or do you let it slide? Do you as an arbitrator leave yourself open to finger pointing later on for not having disclosed something of this sort? Or do you do the good thing and disclose it? I would always tend to err on the side of caution and make that disclosure. But that disclosure then has other ramifications, because parties who don't want you as counsel are going to pick that up and say, well, you've made a disclosure, now the consequences must flow. We have an objection, therefore, to your continuing as an arbitrator or being appointed as an arbitrator on the matter. And this can make things slightly piquant, I think, for seniors who are being appointed. And this is not an academic dispute. I was very interested to find that this precise question went to the Bombay High Court. And there was a senior counsel who was appointed as an arbitrator by one of the law firms for whom he not only appeared previously, but continued to appear. And in my opinion, continuing to appear for a law firm as a senior, maybe on an independent brief, is something that does fall within the meaning of Schedule 7. Interestingly, the Bombay High Court took a different view. The Bombay High Court held that appearing or acting for a law firm who is a law firm in the dispute means not as senior counsel for a firm, but in fact means appearing for that firm as a client. And by way of illustration, the Bombay High Court said there are instances where law firms go to court themselves as litigants, for example, on matters of service tax or bar council related issues and so on. I think that is giving the benefit of the doubt to the arbitrator. I don't think that was the intendment. I think when as seniors you appear for law firms for hefty fee, these are matters that necessarily must be disclosed. I have a direction from Adrian to wrap up in 1 minute, so let me very quickly cover 2 points. One is, what is the effect then of not disclosing your conflict? I was involved in a litigation where a retired judge whose daughter happened to work for one of the law firms previously, and that law firm was a party to the litigation, did not make a disclosure. Now, this was something very well known to both sides, but one of the sides kept their powder dry, let the arbitration take place, failed in the arbitration, and then raised that as a matter to challenge the award. And I think this is something we also have to look at when challenging an award. To what extent do these non-disclosures vitiate the award completely? Are they derogable or not? Should they lead only to strictures on the arbitrator, or should they lead to the very award itself being vitiated? I did also want to talk a little bit about counsel conflicting arbitrators, but maybe I'll come back to that, time permitting, Adrian.
Thank you very much, Aditya, and for sticking to the 7 minutes. We can certainly, I think, discuss the other question, which is an interesting one, in this next 7 minutes of discussion. Just one observation, if I may. Something that has concerned me slightly about the proliferation of guidelines is, in place of the normal considered, let's say, process by which one decided whether or not one may be conflicted, there is a danger these days to enter into a box-ticking exercise, and satisfying that you move on. The flip side of this is that when I was at the LCIA in a different life, it was not uncommon for arbitrators who had been nominated to call me and say, look, this is worrying me, ought I to disclose it? And my reaction may have been, well, certainly not, it's neither here nor there. But now that you have raised the question in your mind and therefore with me, yes, you must disclose. So that's just a little caution about where we're going with regulations. So who would like to kick off on the panel with any observations on what we've heard from Aditya? Charles, would you like to?
Sure. I just wanted to say, I think the fundamental question is always, what's the perception of the reasonable observer? And I think we've got to take it back to that underlying principle. And we're really concerned about it in the arbitral context because we're concerned about the enforcement, and that's ultimately the issue. Under the New York Convention, is it going to pass the test of due process? Because if it doesn't, then the whole process has been a complete waste of everybody's time, except, of course, for the losing parties, who's slightly less concerned about that. And we've got to ask ourselves, what is it that the reasonable observer is taken to know? That's the critical question, is what's the information base that we apply? There was an example that was very well known in the London scene and internationally about counsel and arbitrators from the same set of barristers' chambers, where when this was considered by English judges over the years, they said, well, what could possibly go wrong? We're all good chaps, we know each other, you can trust us. Of course, if you don't come from the cloistered world of the Inns of Court, then perhaps it doesn't look quite so clear-cut. So the question is, how do we define the reasonable observer? What is she taken to know, as it were?
Thank you, Charles. George?
I'll steal your one. I mean, just to say, I mean, I have to bear out to a large extent what Charles and Aditya have already covered. Fundamentally, I think that it's very important to remember that the arbitration process belongs to the parties. It doesn't belong to counsel, it doesn't belong to the arbitrators, it doesn't belong to the institutions. And with that in mind, I would always want potential arbitrators very much to err on the side of disclosure. I think it's absolutely right and proper. And then judgments can be made from there. I think, of course, there are situations when very cynical challenges are launched with an eye on frustrating the progress of the arbitration. Of course that happens, and of course that ought to be dealt with in a robust fashion. Hello, Zia. But at the same time, that's a price that, in my view, is worth paying for having a process that functions, that is reasonable, that belongs to the parties, and is trusted, above all else, is trusted. I think the last thing I would say on this is it's very unfortunate when one sees arbitrators tenaciously hanging on by their fingertips to appointments, arguing that they are not conflicted, that there is no issue. That maybe they're right in some of those scenarios. Often they're wrong, but maybe sometimes they're right. But in the end, the starting point has to be the process belongs to the parties. Everybody needs to be able to trust in the process.
Thank you very much, George. Naresh, do you have anything briefly to say before we invite the audience to comment?
I don't really have anything much to offer, but it's already been said. Whatever Aditya said, I completely agree with that. And one of the things, obviously, is that you always start off wanting to know whether there are any conflict situations or not. And I remember the time just before the Act came in, there really was nothing. There was no way of knowing in the Indian scenario whether there was a actual conflict or otherwise. And now you see a lot of flurry of activity once you seek to nominate the arbitrator, because there's no arbitrator really wants to be in a situation of a conflict, obviously, and therefore you have now disclosures which come more often than you know, what you would not expect, otherwise what you would not have expected to happen in the earlier scenario. So I think it's a good thing. It's a great thing to happen for arbitration in India. Need of the hour, and it came at possibly the right time.
Thank you, Naresh. I think it would be unfair to ask Zia to comment at this time, as she's only just arrived. But if there are any questions on this specific topic from the floor, we'd be delighted to take those in the next few minutes. I can't see terribly well from here because I've got the interrogation lights in my eyes, but any hands raised on this issue? So obviously dealing with the Q&A right at the end of the topic is not so far elicited any response. In the last couple of minutes we've got before moving to the next topic, Aditya, you mentioned the question of counsel being introduced late into proceedings and creating conflicts. Would you like to have a couple of moments to talk about that, perhaps?
Yes, please. Thank you, Adrian. Now, this is something we see in court a lot, where parties engage counsel to conflict a bench from hearing a matter. It's a very sharp practice. It's part of forum shopping, but it's fairly rampant. But in court circumstances, even if that should happen, it's not difficult for a case to move from one bench to another by special orders, and for a matter to then be taken up once again expeditiously. But as we know in arbitrations, the very constitution of a tribunal is sometimes a long-drawn process. And if an arbitral tribunal that's well underway in the proceedings is conflicted midstream, then that's going to mean going back to square one, reconstituting a tribunal, which we know is not an easy task, and possibly starting proceedings de novo. And that can, I think, be severely bad for the tradition of arbitration. And obviously the onus then is on the counsel that is being approached solely with the view to conflict a tribunal, because you already know the composition of the tribunal. And I'm happy to see that the LCIA rules have already preempted this situation, Rule 18.3, by providing that when a party to an arbitration proceeding intends to change counsel midstream, then that change must be intimated to the tribunal, and the tribunal in fact must approve that change, failing which literally the new law firm or the new counsel cannot appear. I think that is something perhaps MCIA can look at, and that would certainly be a step in the right direction. Otherwise, if counsel let their guard down and indulge in something unscrupulous of this sort, it's going to look terribly bad for arbitration.
I think that's exactly the right rule to have. I remember that we used to have a Judge, Justice Pense, for those of you who have appeared before him. And he had very strict rules. He had a list of counsel who could not appear before him. Finished. That's it. So if the matter was before him, he was the one who was going to get the audience, and whoever the client chose as counsel could not choose from that prohibited list, which is a tough way of saying you can't conflict me out of hearing your matters. And I think the LCI rules is something maybe Nisha and Anita you want to look at to see if this works.
Any other comments on the panel on that particular point? Naresh? George? Very good. Well, with perfect timing then, we shall move on now to Charles's intervention, which is going to be on the subject of third-party funding. Thank you very much for that.
Thank you, Adrian, and hello, Zia. It's a great pleasure to be here. I'm coming to talk about third-party funding. This has been a very big development in my home base in London, as I'm sure you all know. In particular, in litigation, commercial litigation, I would say that a very significant percentage of business-related disputes are now being funded by third-party funders, effectively by funds which have been set up in order to exploit this opportunity. I'm sure you're all familiar with it, but it comes from the confluence of two phenomena. First of all, globally, there is too much capital chasing not enough assets. And so people who have or administer that pot of capital are looking for things to put it into, and litigation has become one of those things. And secondly, the cost of major commercial disputes has gone up, if not exponentially, certainly geometrically, because of electronic documents, lawyers' fees around the world rising. And so the combination of that has led to an interest in funding, even on the part of major corporate clients or ultra high net worth individuals. It is now worthwhile considering funding, taking a haircut of whatever it might be, 20, 30% on your possible returns, in order to lay off the costs, and indeed the costs of an adverse award if you're in a fee-shifting jurisdiction. What does this mean legally? Well, it raises, in my opinion, problems under 4 headings, the 4 C's: confidentiality, champity, costs, and control. The confidentiality issue arises in this way, that funders have to scrutinize cases. They have to decide if they want to put their money into the business opportunity. They bring no baggage, there's no grievance, they're not compelled to litigate or get involved, they have nothing to prove. In order to carry out that due diligence, they need legal support. They tend not to employ their own lawyers, they tend to use panels of external lawyers to vet the cases for them, which are brought to them by the clients or indeed by the law firms involved. They have to find people to sit on those panels, and some of those people, therefore, are going to be senior lawyers, perhaps not on law firms, perhaps independent senior lawyers who will be able to vet the cases and bring their experience to help. In order to vet the case, obviously, you have to be told about it. You have to get lots of privileged information. You have to see it. And this creates a potential problem when we come to consider whether any of the people involved in those funding panels are going to be asked to sit as arbitrators. I mean, obviously, the extreme case would be in a matter which you had looked at. But even if you haven't done that, if it's a case which is being funded by a funder in which you have some interest, not a business interest as such, but which you are associated with, where you sit on one of their committees and you help look at it, even if there's been a Chinese wall in place, how does the other party to the arbitration know whether or not that Chinese wall is effective? And indeed, do we ever think Chinese walls are really effective? So when we come to consider the question of disclosure, the question of conflicts of interest, the question of the perceptions of the hypothetical reasonable observer that we were talking about a few minutes ago, there is an immediate issue that arises there. And in my opinion, this is something which, if you are somebody who wants to be an arbitrator, who regularly sits as arbitrator, you should really steer clear of funders, because it is going to cause big problems. That's one issue. The second issue I mentioned, champity. We all know that champity comes from the Latin campi partitio, a division of the spoils, and at common law around the world, this was unlawful. Indeed, it was a tort and a crime, although that's usually been abolished now, but it remains unlawful as a matter of public policy, according to traditional common law, to enter into an agreement to divide the fruits of litigation. Now, in England, we've had a lot of indirect consideration of this, and it's been accepted in a very English way. That is to say, without anyone actually ever saying the old rules have changed, we have just tacitly accepted this is no longer the way we do things. And the way we do things now is to accept that third-party funding is not champitous at all. It is part of, quote, access to justice. One man's tort is another man's access to justice, it seems. But that isn't necessarily the case in every jurisdiction in the world. In India, I would imagine, it has not yet been so accepted judicially. In Ireland, to take an example, there was a decision of their Supreme Court, what they call the High Court, last year, which said this is still unlawful. Champity is still unlawful, a case called Paisner and Sigma against the Irish government, which was brought by Harbour, one of the big funders, and they lost. So let's look at this in the relevance of an arbitration context. You've got an arbitration funding which takes place in a country, in a jurisdiction where this is perfectly okay. But then you come to enforce an arbitration award which has been obtained through the funding of the claim. Will it be said, well, enforcement of that award, let's say here in India, for an international arbitration is against a fundamental rule of Indian public policy, which even under the most recent Supreme Court decisions would still be regarded as a fatal objection because it has been obtained through the funding of litigation, which is a social evil that a fundamental rule of Indian policy prevents. That's something which has not yet been tested and which needs to be carefully borne in mind if you are potentially going to enforce in a jurisdiction where champity is still alive and kicking. Third issue is costs. In litigation, where we have fee shifting, so in the UK, the funder can be ordered to pay at least the amount of costs that it has agreed to contribute. So if you fund a case, you lose, you, the funder, must pay. That seems obvious and fair. Arbitration raises a different set of issues because it will be said, well, the the funder's not a party to the arbitration. What jurisdiction does the arbitral tribunal have? Has there been an implied submission, at least for the purpose of that? Or are there yet perhaps some other forms of redress which we could obtain, maybe using contractual rights in the country of the funding agreement? One way is to do what Gavin Griffith did in a recent decision, which was to order security for costs. So if you know there's a funding agreement, at the very least the funder must put up the money, and then we don't need to worry about enforcing the cost award. And Adrian, if I've got another minute left, I do. I'm going to talk briefly about control. One condition which does appear to still remain under the law of Champati is that the funder shouldn't have control of the litigation. That would be regarded, it seems, as improper. But what they do have is control over the purse strings. So they can say, we don't like the way this case is going, and under the terms of the funding agreement, we can pull out if we determine you no longer have a good enough chance of winning. Now, you can tell me what you like about control, but if somebody says, I'm going to turn the tap off, he controls what I'm drinking. That's my attitude. So those are the issues that remain. What we can say, I think, with some confidence is that funding as a practical phenomenon, A, is here to stay, and B, is jolly good news for everyone in the litigation industry.
Thank you very much, Charles. Impeccable timing, if I may say so. Just a thought before I throw it open to the panel and to the floor. Third-party funding now, of course, is big business. We understand that. It's with us, and it will be with us from here on in. But to some extent, there's been funding from elsewhere around in litigation and arbitration for a very long time, whether it's one's wealthy uncle or whether it's your local bank or whether it's an associate company and so on. And of course, that hasn't raised the same issues as are raised now by this industry, if you like, of third-party funding. Zia, do you have anything to say on this subject?
So I think that every claimant is required to disclose if he has third-party funding. Am I right? Okay. So I think that from an Indian point of view, it is more than likely that this would be considered as against public policy for the moment. It's not been tested, but Champati is still the law. And I think the moral hazard in a judge's mind will still be perhaps deeper than the access to justice argument. And so it would be interesting to see if when there's an Indian party involved, just to make sure the award is enforceable against the Indian party should it come to India, the third party funding risk needs to be highlighted to whoever is a party to the agreement.
Thank you, Zia. Anybody else on the panel? Naresh, would you like to? And in the meantime, could those of you out there please be thinking about a question or two? That would be grand. Thank you.
No, it's interesting that we say that this is something which has not been tested in the Indian courts. Actually, there is a decision of the Supreme Court of India, a 1952 or a 1954 decision of Justice Vivian Bose. And that was a matter where para 11 of the judgment very clearly, issue actually was of Champati. One of the lawyers having done a Champati deal, and therefore the question was that whether that is against public policy or not. In that context, the judges actually in para 11 go on to say that while Champati for a lawyer not allowed, funding nonetheless by one person to the other could be allowed as not being against public policy, though they have not used those terms, but what they have said is that that is a matter of contract between parties, and in a given case that could be something which could be seen in a positive light. But nonetheless, having said what they have said, they really did not go into that issue because that was not an issue really in the matter. So what they did was that in the very next paragraph they left it for some better facts-based case to decide on. So, you know, anyone's guess what happens, you know, when an issue of this kind actually goes to the Indian courts now.
Thank you, Naresh. I heard Zia mutter, "Don't count on it," as you were recounting that. George?
Yeah, just a couple of observations. I mean, first of all, as Charles referenced, this type of thing has existed in different forms for a long time around the world. What do insurance companies do when they have legal indemnity policies? What do trade unions do? What do protection and indemnity clubs in the maritime industry do? All of these exist to provide financial support to those who are litigating in one form or another. This is just another version of the same thing. That's not to say there aren't some important issues to deal with. There are, and the disclosure issues and the idea of security for costs applications that might flow, this is a slightly tricky area. But to my mind, there's no principled objection, be it on the basis of moral hazard or anything else, that should prevent us allowing this and encouraging it, because in the end it really is about access to justice. I have had a number of cases which have been funded, and although Charles references the possibility of control as a risk item, to be honest, from an anecdotal fashion, I would say, yes, that may theoretically be a problem. Actually, the funders that I work with never want to get in your way, respect that we are the experts, that the case is going to work best if we do our job, our clients are able to give proper instructions, and we keep the funder fully briefed. So it's never, in reality, in my experience, and I've never heard of it being a real problem, but I understand there could, in theory at least, be issues there. And there are certainly some hints at some, not exactly third-party funders, more the hedge funds who are coming into this world, who may be approaching things in a slightly different way. But the final thing I'll say on this subject is that far from being something to be suspicious about, I think it should be encouraged, but I'm very critical of the third-party funders that are out there at the moment, because to my mind, they are not taking on enough risk. They are looking for safe cases too often, and also they are safe cases with a very high minimum amount of recovery. So if you have a case that is a substantial international arbitration case that is where the projected recovery is anything less than $20 million, frankly, you won't get it funded straight off the bat, no matter how good it is. If it's over that sort of threshold, you will find it difficult if there's even a small issue in the case. They are not willing to take on serious risk at the moment, and I think it's a very immature market. There is a lot of scope for new players to come in. They are coming in, but they need to be taking on more risk, not less.
Can I just briefly respond on that point? Just everyone will have their own experiences. It's not a completely transparent market. I mean, I was involved in something recently where there was an unusual case, and there were 2 or 3 funders who were interested, in fact, putting forward competing proposals. It was certainly not free from risk, and the reason the case hasn't yet gone forward is because the underlying clients, who are actually being offered a full indemnity against their exposure, aren't willing to take it forward. So every case is different, and what I'm seeing is a lot of competition between funders to get their money out and deployed. You have a lot of people who've set up these funds, city boys, if you like. They've got to make a living, and they can only make a living by investing in cases. So I would say there is an appetite for risk, and that's where the control issue comes in, because they're also conscious of the fact that they can't always get an accurate opinion from the lawyers who've been dealing with the claim.
Thank you, Charles. Aditya, anything to say on this?
Yeah, I'd like to make an analogy with the Supreme Court of India's rules on public interest litigations. And as many of you may know, when a PIL is filed in the Supreme Court, one of the mandatory disclosures is as to what is the source of funds for that litigation. And the moment that disclosure is made, it links up to whether it is a bona fide funding for access to justice, as Charles argued, or the counter, which is simply shadow boxing and mala fide litigation. And I think the same test perhaps needs to be applied even to arbitrations. When we talk about funding access to justice in arbitration, then the question is, what is the nature of the transaction between the funder and the recipient? Is it a loan, or is it contingent upon the outcome of the litigation? Is there a share in the proceeds of the award? After all, it's for good reason that we don't have a contingency fee practice for lawyers in India. Otherwise, why not have lawyers fund arbitration subject to the outcome of the result? So I do think that there is a serious ethical question to be asked as professionals in this matter. It's obviously a policy decision to be taken after much thought, but my prima facie view is that if something like this was to be taken up to court and tested on the touchstone of Section 34, public policy, corruption, morality, and so on, I have serious doubts whether it would pass muster.
Aditya, thank you very much. And are there any hands? I beg your pardon, Naresh.
Adrian, just if I may add, now that Aditya mentions about the Supreme Court rules, there is in the CPC a provision which requires disclosure of funding, if any. CPC and Maharashtra, if I'm not mistaken, has actually made rules around it. So the Civil Procedure Code actually in a way recognizes that third-party funding is actually around, and that if it is there, you need to disclose it.
Thank you. I see a couple of hands. I can't see the faces, but I see a hand. Gentleman here, please. Could you give your name, please?
Hi, Madhur Bhaya from Lex Arbitration. The two observations that I wish to make is that champerty as a matter of Indian law is not actually illegal. We don't have the same position as it obtains in England, or used to obtain in England. This position is right from Privy Council days up until now. So that's one. The second issue, Aditya, I don't think I would agree with the analogy you draw with the PILs, because PIL has an issue with funding, because typically you would have a PIL against public projects or things of public importance. And who is funding this is usually an issue, because there is shadow boxing there. And the third observation is that when it comes to third-party funding, the practice worldwide is nobody puts their hands in their pocket unless they have had an independent determination what are the chances of success. And only at a hit rate of 60% plus will they even say that here is a proposal for third-party funding. It's not that every case will get third-party funding. So there is that assessment which is independently made. What are the chances of success, and depending on where you get at, there is this percentage of share which you have from the spoils. So it's all pretty much okay, according to me.
Thank you very much. One other question. Robert, I think, is it?
Yes, it is. Your glass is good. Yeah, Robert Hunter. I have three very, very quick questions. The first of Charles. I'm absolutely not an expert in Shaftee. I didn't even know the Latin root. But are the objections based upon the more public aspects of administration of justice, or are they relevant only to litigation and not to a private process of arbitration? The second is, it seems to me there's nothing to prevent the parties dealing with the question of disclosure or even of funding in their arbitration agreement. That may be an argument that perhaps differentiates it from litigation. It seems to be a very significant point. The third is, in terms of India becoming an international seat, one approach might be, unless it's, it would be hard to say it's part of jus cogens against funding, I think. Perhaps you could, but it would be rather extreme. You could take the approach of the English Unfair Contract Terms Act and say that if the dispute would not otherwise have any connection with India, at least it should be allowed for disputes that have no such relationship.
Thank you, Robert. Can we, in about a minute flat between Charles and Zia, perhaps just deal with those couple of points? Charles from the direct question and Zia from the Indian perspective.
In answer to your question, the roots of Shampati indicate that a promotion of disputes is regarded as was the underlying problem, and that would apply, in my view, equally to arbitration as well as to litigation. It would also mean that it wasn't particularly relevant whether the parties had dealt with it in their agreement, because it isn't a matter between the parties. And perhaps Zia will be able to say a bit more about the Indians.
So I think that, this issue is not settled, and it is out there and will be tested. And I think it would be sage advice to tell clients that there is an issue about enforceability should you take third-party funding. I think borrowing from a bank to fund a litigation is different from saying I'll get 20%, I'll get 80%, I'll get 70%. And I think that that's how the courts would have to test it and to view it and to come to a determination. I personally feel third-party funding is here to stay globally. I think in the Indian context, how it gets nuanced and the moral hazard in the judge's mind is dealt with is still out there.
Thank you very much. So we're now going to move on, and yes, that's a good idea. As a amateur dramatist in my early life, I could always project my voice, but not to this extent, I think. George is now going to address us on the question of summary judgment in arbitration. George, thanks very much.
Thank you very much, Adrian. Before I address the audience on the topic at hand, let me just first of all say what an honour it is to be here to be able to make a contribution to the excellent initiative that is the MCIA, which I am positive is going to see the conduct of arbitration, both international and domestic, develop apace in this country. The second introductory point I just wanted to make, in case anybody present is Sikh, is to wish everybody the best for Guru Nanak Jayanti, which I believe falls today. Thank you very much. Okay, summary judgment. Even the phrase, to my mind, slightly jars, because judgment is something that a judge in a court will issue rather than arbitrators in an arbitration will issue. But let's not get too hung up on the semantics of phraseology. What does it mean? Well, it is essentially a process by which a tribunal or a court grants judgment on a claim or a defence, because there is no genuine issue of material fact, and the moving party is entitled to judgment or an award as a matter of law. So it's effectively shortcutting the process. This really sees us wrestling with two core elements in the philosophy underlying arbitration. It is a clash. Look at provisions in legislation such as Section 18 of the Indian Arbitration Act, which is very close in textual terms to Article 18 in the Unscharged Model Law. You can look at Section 1 of the English Arbitration Act and Section 33 of the English Arbitration Act. All of these instruments and many others speak to this desire for efficiency of process, but also for fairness. And there are many cases in which one it butts up against the other, and it's difficult to work out the best way forward in order to respect both. Let me really start by looking at a case I was involved in last year. I was representing a bank, an international development bank, that had lent about $40 million to a Mongolian mining company. The mining company had defaulted on the loan. It was a lot of money, of course, but essentially the claim was a debt claim. It was a very simple, vanilla debt claim that the bank sought to pursue. It had an arbitration clause in the loan agreement governed by UNCITRAL arbitration rules. So it brought the arbitration, instructed my firm to bring the arbitration in order to take the first steps towards recovery. The claim was very simple. The respondent came up with a very, very creative defence and a very substantial counterclaim for approximately $120 million. But the nature of the counterclaim, although very creative, was in the end very thin in terms of legal rationale. And so we looked at this and we said, well, even if they're right on all of the factual points that they allege here, and our client told us that they were wrong on virtually everything, we were still going to win. That defence was going to fail, the counterclaim was going to fail. So we presented a request to a very well-respected Singaporean arbitrator, sole arbitrator, and we said, look, we need to shortcut this. We need to get rid of this defence and counterclaim, not because they're not entitled to present it, because they have presented it and it won't work. Whatever happens, they're going to fail. Why should we invest huge amounts of time and money in this thing that's going to fail? The arbitrator in the end, he's a superb arbitrator, I have no problem with that, felt he didn't have enough, he wasn't sure enough that he had jurisdiction to grant us our application. And so rather than reject our application on the merits, he said, I'm sorry, I don't have that power. We're going to go through the whole arbitration. I would say, off the top of my head, about 3/4 of the lawyer time spent in that case was spent dealing with this defence and counterclaim, because it raised all sorts of factual issues. We had to look for documents in London, in Hong Kong, in Mongolia. We had to interview witnesses in various countries. We had to deal with all sorts of things to deal with what was always a very weak case. We did win, great, that's fantastic, but it cost a lot more time and a lot more money to do so. But the real question here is, why did the arbitrator feel that he couldn't give that sort of order? Well, it's understandable, and there are lots of authors who will say that this is something that where there isn't jurisdiction, if it's not spelt out in the rules or in the arbitration agreement, it's going a bit far. It's encroaching on a party's right to be heard, the right to due process. And that is really the core issue. Now, there are some rules, some arbitration rules, which do indeed have this power. there have been reports. There was a report on by the ICC Commission on arbitration for banks and financial services, and this is something that comes up very regularly in that world. And they said that the users there said one of the problems with arbitration is there is not enough power to deal with things summarily. But recently, the ICC has issued a practice note which says, actually, it may not be spelt out in the ICC arbitration rules, but there is enough scope in Article 22, which sets out the powers of tribunals thank you very much, to deal with things, and arbitrators can proceed confidently on that basis. But still, there are plenty of people, good authors like Gary Bourne, like Judith Gill, who quite rightly draw attention to the absence of text in rules or clauses. And Gary Bourne says the best thing to do is to write it into your clauses, advice I wholeheartedly endorse. But there are some rules that have started to emerge that have provisions like this. The Singapore International Arbitration Centre, very familiar to many people in the room, at Rule 29 in its latest set of rules, has a procedure for dealing with it. Talks of manifest lack of merit. The Stockholm Chamber, which will be less familiar here, but is very familiar to anyone working with parties or projects in the former Soviet Union, also has something in Article 39 in its rules. I would love to go into the detail of those because there is some interesting differences of approach in those two provisions. But suffice to say, there is something there at least for parties to get hold of, something that can be used fairly to bring to an end claims or defences or counterclaims that lack proper legal merit. And this is to be welcomed. We should be confident in encouraging it. It is what users of arbitration generally want, rather than allowing arbitrations to continue with too much time and too much cost involved. Thank you very much. Oh, and can I just say thank you also, Rahul Donde, for the reference to the American comedian at the beginning. I actually haven't heard that reference for a few years, so I'm delighted that someone so young as Rahul knows who George Burns is.
George, thank you very much indeed. It might, I think, be interesting to hear from the Indian perspective about the whole question of summary judgment and arbitration. I don't know whether one of our... Aditya, would you like to say a word?
I'm reminded of the provisions under the CPC dealing with summary suits, Order 37, where when a court is confronted with a case under that provision, it needs to determine whether a defense is a moonshine or not. And if found to be in bad faith or an afterthought, the court does have the power to then proceed to summary judgment. And that's the same analogy that was then extended under the Indian Companies Act of 1956 while dealing with winding up petitions for inability to pay one's debt. And as was customary in many cases, the defense surfaced for the first time when summons of the case went to the respondent. There was no inkling of a dispute pending the litigation. There was no reply to a statutory notice. In fact, there may be instances where the debt was in fact admitted, acknowledged in the books of account and so on. And those were principles that were developed both under Order 37 and in liquidation. And I would think that it would be apposite to extend them also to arbitration, of course, with a specific provision in the Act. Because in the absence of such a power vested in the tribunal, there's a very good chance that when challenged under Section 34, the court sitting in judgment over the award may say that you have not followed due process, you haven't heard a defendant, you haven't given them an opportunity to lead evidence, and so on. But I do think to deal with exactly the sort of cases that were mentioned by George, we need an express power of this sort.
Thank you very much. I've just seen an alarming note that says 5 minutes, and I think that may apply to the entire session, although to be fair, we started a little later than our allocated time, so you'll have to indulge us to some extent. But on the basis of that warning, I think we should move now to the final presentation, otherwise Naresh will have no time to say anything at all. So, Naresh, would you be kind enough to let us have your remarks on the question of expedited procedure in arbitration? Many thanks.
Yeah.
And emergency arbitrator, but I didn't say that simply because you may not have enough time, but we'll give it a go.
Thanks, Adrian. Time is money. I now understand it completely. Adrian has been drilling that into all of us all the time, and now Rahul has made it all the more clear. Obviously, expedited procedure steps in exactly for that situation to help you to address both time as well as cost in arbitration. Under MCIA rules, Rule 12 is what addresses the expedited procedure rules. There are two situations in which you can actually have expedited procedure. One is where you have the amount involved in the dispute, whether it's the claim, counterclaim, or a set of defense, which is not more than INR 100 million. And the second is where the parties actually agree. Now, one of the situations is that to start off with an expedited procedure, the party really needs to make an application to the registrar. Obviously, what it means is that there is no opt-out provision even in an expedited procedure. Once you are in the rules, once you have accepted the rules, you have to accept them wholeheartedly. And you will, if a party starts or wishes to start an expedited procedure, you as a respondent will have very little say really, if at all, to actually stall that process. What is the procedure? It can actually allow you to shorten the time limit under the rules. Whatever may be the time limits, those can be shortened. Appointment of sole arbitrator, notwithstanding any agreement between the parties, one of the issues always has been for expedited procedure, the party autonomy. The fact that it actually takes away a part of the party autonomy, and this is one of the aspects of party autonomy which is actually taken away, which is that if you've agreed on 3 arbitrators, you may have to lose that, and you may enter into a situation where you can at best have a sole arbitrator. Obviously, that is an issue which will be decided by the chairman after having had discussions with both sides and after having considered the submissions on both sides. The tribunal has to hold hearings, and that's surprising that the rules actually say that the tribunal will actually hold hearings unless the parties have decided otherwise. So if the parties actually do believe that the hearing is necessary, then obviously the tribunal will continue. If not, and if the parties do make submissions on, or rather the parties agree not to have the hearing, it's only on those situations that the tribunal will actually go on documents only, which obviously in the Indian context also means that a lot of time will have to be spent on the cross-examinations, on the final arguments, and we all know what happens when we get a speaker spot anywhere, whether it's here at MCIA or at any other tribunal. Award to be issued within 6 months. The time limit can be extended under exceptional circumstances. What those exceptional circumstances are anybody's guess, and I'm sure over time we'll all understand how this subjective element is actually dealt with. Insofar as the award is concerned, the tribunal actually is to state reasons for award unless the parties have agreed otherwise. So the tribunal will be required to at least give a summary of the reasons before an award is issued, and I can understand why, because in the Indian context, again, if there was a decision which was merely given without any follow-up reasons, then certainly that is amenable to challenge in the courts. Interestingly, if you see Section 29B of the Act, that as well provides a fast-track arbitration procedure, quite similar to what you have in the rules. So therefore, to my mind, the MCIA rules really in that sense supplement what the Act now requires. All in all, to my mind, great. It is the summary procedure that we've been talking about, and to my mind, if correctly used, can really, really help not just shorten the time, but also a lot of expense, which actually people do end up spending in a long drawn battle, can really be taken care of. So I really have just 1 minute. I don't think emergency arbitrator is something that I can cover. Just one question that had come.
Naresh, I just want to clarify with the organizers, forgive us, but we certainly started 5 minutes late. With your indulgence, we'd like to overrun by 5 minutes if that's permissible. Thank you very much. Naresh, please, in a minute or so.
Thanks. On the issue of emergency arbitrator, again, there was a question which had come in one of the sessions in the first half, and the issue was that what happens in a scenario now when once the tribunal is constituted, you really, in a sense, lose out on your on the benefit of Section 9, and you really have to go to the tribunal under Section 17, and the tribunal is on a long leave. What do you do? Though that situation is actually addressed by Section 9 itself, because Section 9 then brings you back into the realm of the court. But there is help at hand through the process of emergency arbitrator. You have the MCIA rules, Rule 14, which actually allows you to seek the constitution of an emergency arbitrator between the time that a reference has actually been made and the time that a tribunal is actually constituted. The application actually needs to contain four things, four elements. What is the nature of the relief? What is the urgency that you actually have? What are the reasons for that entitlement and notice to the other side? I actually want to touch upon one topic on emergency arbitrator bit, and that is the question of enforcement. Emergency arbitrator, even if you look at the rules per se, you look at the definition of tribunal, it does not actually include a emergency arbitrator. You look at an award, the definition of an award, it does not actually take into account, in that sense, the order or the award of the emergency arbitrator. You look at Rule 20 by them itself, it actually calls the order as an award. Now, whatever term that you may need to give or you may want to give to the order, it really remains an interim order of the tribunal. How will it be dealt with by the courts? And the Indian courts have actually dealt with in two of the current, or if, I don't know whether I can really call it current, because the first time this issue arose in 2014 before the Bombay High Court, and the Bombay High Court, so I'll just complete my point. The Bombay High Court actually in Avitel said that while we cannot recognize, they did not recognize the emergency arbitrator's award or the order, but they actually passed an order under Section 9 in the same terms. That is exactly what the Raffles design, the Delhi High Court said. So to my mind, there is an indirect way of actually enforcing the award of the emergency arbitrator, and that's exactly what I would actually expect the courts normally to do. Thank you.
Naresh, thank you very much. I shan't be encouraged by Zia to do as she tells me that Indian moderators normally do, and that is simply ignore all the requests to stop. We shall stop there with apologies that we weren't able to take questions from the floor on some of these, but to recommend that we have a conversation over cocktails later if there are burning questions you'd like to bring to the members of the panel. Thank you very much indeed.